Representative Peterson.
Thank you, Mr. Chair. So my understanding of this, again, coming back to 222 to 225, that this only does not prohibit those in-kind contributions during the general session. Is that right?
Sorry, state that for me again.
So this is carving out an exemption for the general session, saying that this can happen during this period of time. Is there anything that would prevent someone from entering into that in-kind agreement just prior to the general session or sometime prior to it, knowing that signatures were going to be gathered during that period?
Right, that's a good question. And currently, and Mr. Thomas certainly can correct me if I'm wrong, but my understanding is as long as the contract is completed and the work hired for is during the session, that contract can be completed during the session, or before the session can be completed during the session, right?
So the in-kind contribution and contractual arrangement can occur before the session, but be implemented during the session today without this wording. Okay, thank you.
That's one. The other element that also needs to be watched out for is the question of that person's that has a duty to report under our financial disclosures law. If they have this duty to report, there is a question as to whether or not their personal activity counts as well, number one. Number two, if there is a scenario that comes up as a result of that contract that requires a change or a difference, that change cannot be made during the legislative session, despite the fact that some situation may occur that makes it difficult for that to move forward or that work to change.
Chair recognizes our and this may help with your question, our staff attorney, Mr. Vaughn.
Just one item of clarification. The scenario you described with the contracting before is the way that the Lieutenant Governor's office has said that they will interpret the law. I'm not going to say that they're wrong, but what I am going to say is if someone were to challenge it, it's possible a court may come up with a different interpretation. So this language would clarify that situation where that kind of challenge couldn't arise in relation to this particular conduct. Does that make sense?
Yes.
Okay.
Doesn't make me happy, but it makes sense.
Representative, I'm with you, and I'm with you as well. I don't like generally where we are on some of these issues. And I'll just take a moment and step on my personal stump. What I wish that we had done is had all the campaigning and all the electioneering, everything else happen after the session. The difficulty that came as a result of that, and this was during the election reforms of what was that? My goodness, all these sessions now fade together, and I don't know how Patrice does this. Sorry, Representative Aaron does this, but for this many years. But the election reform of a couple of years ago, making it so that it would happen, I wish, like anything, the change was different, to move it all after the session. But in order to do that, we had to move the primary to the latter part of August and September. And there were many who felt like that wasn't a good alternative. I'm with you and several of you. I would have been fine with that option, and I'm still fine with that option. In fact, that was one of the things that I was hoping to accomplish, had a special session been called, but I don't have that option now.
Thank you.
To be very transparent, how's that?
One more clarifying question from the committee. Representative Peterson.
Thank you. I just have so much to say. I guess I'm having a difficult time getting over this idea of us being able to negotiate contributions during the session. That's just really uncomfortable, I can't get over it. And I also believe that that if we have our wits about us and we are running for office or re-election, that we could negotiate these contracts and work in advance prior to the general session, and then we can go about our business during the session and then come back to it after the fact. We've gone to great efforts and lengths to kind of create this safety zone during the session where the perceptions of influence are not there. Right, we try to keep that safe separation, and so this seems to be taking a step backwards in that regard. and also with the efforts that we've made to create the sanctity of the general session, it seems the threat of a court case where a court would interpret an in-kind contribution as being received during the session, when we have specifically, if we were to strike these lines, to say no, we're not going to accept a contribution. That seems there seems to be an irony there that I just couldn't see that being highly probable, right? If that's our intention to eliminate that negotiation from occurring during general session time. So, anyway,
Is that a question?
Yeah, what do you think?
Yeah. I will add, and I can't remember the exact numbers. I knew it 2 years ago when we were looking at the election reform. We are one of the few states that absolutely bars and prohibits contributions during the session for any purposes. A lot of that is because there are plenty of states whose legislatures meet year-round, and these kinds of activities go on year-round. There are plenty who do. Now, I love the way we do it in Utah and prefer it to be that way. The action, the idea that we have the session and we don't have to deal with the contribution element of things is one thing, and I can certainly appreciate that. I can't fault you for having those feelings.